Okay, good afternoon and welcome. My name is Joseph Kearney, and it is a great privilege for me as Dean of the Law School to welcome you to Marquette University's annual Nies Lecture. I do this not only on behalf of my faculty colleagues specializing in intellectual property law, Professors Bruce Boyden and Kaylee Murray, as well as Professor Irene Kalbally, who is on leave in Singapore this year, but really for the entire Marquette Law faculty. I want to begin briefly by remembering the person in whose memory this lecture stands. The law school created this annual lecture in 1998 to honor the late Helen Wilson Nies, who had served as a judge of the United States Court of Appeals for the Federal Circuit. This was at the suggestion of our then friend, pardon me, I meant to say our then colleague and still friend. I'll be hearing from him soon. Professor Craig Nard, who secured the enthusiastic assent of our community and of Judge Nies's family. Craig had had the privilege of clerking for Judge Nies, and he remembered her to us as a very generous individual and a hardworking, serious, and modest judge. Over the years, then, we have been able annually to host a distinguished leader in intellectual property law as our Nies lecturer. This year, with the encouragement of my colleague, Vice Provost Jean Hassenlapp, we offer the Nies Lecture in support of the Healthcare Economics and Innovation Consortium, which a number of universities in this region, including Marquette, created at the beginning of last academic year. And we maintain our tradition of excellence established by previous Nies Lectures, which have brought to the law school and to the larger communities of which we are a part folks ranging from Richard Posner to Mark Lemley to, most recently, before today, Jane Ginsburg. For today, we have with us Arti K. the Elvin R. Latty Professor at Duke Law School. I should think that this chair is a particular honor at Duke because the late Mr. Latty served as a professor and even dean of the Duke Law School, or should I say, served as dean and even professor. Professor Rye is also affiliated with the Duke Institute for Genome Sciences and Policy, but she is recognized well beyond the Duke campus as a leader, indeed as an internationally known expert in intellectual property, administrative, and health law. Professor Rye's extensive academic work includes top law reviews, yet extends beyond them to encompass such publications as the New England Journal of Medicine. Her policy work includes service in 2009 to 2010 as the administrator of the Office of External Affairs at the U.S. Patent and Trademark Office, including policy analysis of the patent reform legislation that ultimately became the America Invents Act. She is also a terrific lawyer, previously practicing at Jenner & Block in Washington, D.C., and is an honors graduate of Harvard College and Harvard Law School. Please join me in welcoming this year's Nies lecturer, Professor Arti Rye.
So thanks very much, Dean Kearney, for that incredibly generous introduction. I also want to thank you so much, all of the Marquette community, for inviting me. I'm truly honored to be delivering this lecture. The title of my talk is Patents, Markets, and Medicines in a Just Society. As the title suggests, I plan to cover a fair amount of territory in a relatively short amount of time, and so I will move fairly briskly across the regimes of patent law, policy surrounding federal biomedical research funding, and health insurance policy. Although the territory is large, each of these areas is critical to what might be called the biopharmaceutical innovation ecosystem, and thus I think it's important to cover all of these areas. These areas also figure prominently in a particular case study that I will discuss, and that is the almost 15-year-old controversy over the breast cancer gene patents held by Myriad Genetics. The Supreme Court will actually be deciding this term whether these patents represent eligible subject matter for patent law. The oral argument in this case will actually be held next Monday, April 15th, so the case study is a quite timely one. I will conclude by looking towards the future, where I expect that because of cost pressures created by expensive new patented technologies like biologics drugs, we will see perhaps even more tension between patents, markets, and access to medicine. So let's begin with an overview of the ecosystem. One central element of the ecosystem, and obviously very relevant for purposes of an intellectual property lecture, is, of course, patents. For many patent commentators, and particularly I would say patent lawyers, promoting innovation is the central goal of patent law. On this view and this perspective, patents harness market signals to determine what sorts of innovation should be produced. Now, as I'll discuss just briefly in a moment, determining exactly how patent law requirements should be interpreted best to promote innovation can be controversial. But at least among most patent lawyers, the goal of innovation and only innovation is not particularly controversial. The idea is that patents are supposed to promote innovation. Access by end users is for different regimes, other regimes. The public funding of biomedical research regime is a very important additional piece of the ecosystem. Here, most of the funding comes from the National Institutes of Health, which has a budget of about $30 billion per year for funding research. This public funding regime actually intersects with patent law in interesting ways that I'll discuss in a moment. And traditionally, the main goal of this regime has also been to promote innovation. However, in this arena, we begin to see a bit more pressure to bring patient access goals into play. And then finally, we have the health insurance system, both public and private. On the health insurance front, I think it's fair to say that a primary goal is patient access. The related question of cost and whether the price charged by the innovator is worth the health improvement provided lurks in the background. So with that overview, let's dig a bit deeper, starting again with patents. So here's a somewhat forbidding picture of the Patent and Trademark Office where, as Dean Kearney indicated, I worked for a little bit over a year as their chief policy analyst. I think even among patent insiders, and the PTO is obviously a central locus for patent insiders, it's acknowledged that the patents to innovation story is hardly simple and straightforward. Rather, patents can be a double-edged sword. Although they can promote innovation by the patent holder, if patents are too broad or they're vague and unclear, they can also impede innovation by those who might want to improve upon the patented invention. In certain industries, such as telecommunications, this trade-off can actually become very intense because all players have lots of patents and accumulate huge patent portfolios. And we even have so-called patent trolls that accumulate patents only for the purposes of assertion. So just quickly, I'll show you this very ugly chart of what the current litigation mess in telecommunications looks like. The pink ovals are practicing telecommunications companies engaged in litigation. The hexagons are the so-called trolls. Now, this is a worst-case scenario. However, some of these problems do come up with patent assertions in the biopharmaceutical industry as well, and I'll talk about that a little bit when I discuss the Myriad case. So in biopharmaceuticals, we have this initial question of how best to promote innovation, as we have in all areas of innovation. However, in biopharmaceuticals, unlike telecom and other areas of innovation, as I've already suggested, we have the additional issue that there is not even agreement that innovation is the only goal. By contrast, in most other areas of patent law, it's probably more accepted that innovation is the only goal. So in biopharmaceuticals, again, once we move beyond patent law per se to the significant role of federal funding biomedical innovation, the competing goal of patient access definitely becomes an issue. Let's dig deeper then into federal funding. As I've mentioned, NIH is the big player here. NIH thinks a fair amount in innovation-related terms. It actually secures patents on its own internally funded research. And it's also been quite supportive of a piece of legislation known as the Bayh-Dole Act of 1980. This act allows the recipients of federally funded research money to seek patents on the fruits of the inventions they create using that money. The idea behind the Bayh-Dole Act is that even though patents are not necessary for generating the initial invention, that's what the federal funding is for, they can provide the necessary exclusivity incentive for industry to commercialize the research. So the paradigmatic example that Congress had in mind when it passed the Bayh-Dole Act was a drug compound that might be discovered in a university, but would need a patent in order for industry to be interested in taking it through expensive FDA clinical trials. The estimates these days of the cost of clinical trials are at least in the hundreds of millions, if not over $1 billion. So that was the paradigmatic example. And in fact, since 1980, and particularly since 1990, universities have really picked up this innovation theme, again, particularly in the biotech and pharmaceutical areas. They are big boosters of the innovation idea. But in this space, we do see much more concern about access, perhaps because federal funding was involved in the initial creation of the invention. The Bayh-Dole Act itself says that where the patent owner or licensee is not meeting health or safety needs appropriately, the government has a right to come in and demand additional licensing. This is the so-called march-in provision of the Bayh-Dole Act. Some parties who have asked the government to, quote, march in, unquote, have even pointed to legislative history suggesting that overly high prices for inventions that were initially funded by the government might be considered a failure to meet health and safety needs. That's not been an argument the government agencies have generally agreed with, but the argument has been made. So access and even cost is definitely a big theme in this space. Universities have also been concerned, for the most part, I will suggest Myriad represents a notable example. Universities, for the most part, have been quite concerned about making sure that in the licensing of their inventions, end-user access is considered, particularly in the context of situations where lots of additional investment is not needed. So drugs represent a situation where lots of additional investment is needed in order to bring the invention to market. Diagnostic tests of the sort that are issued in the Myriad case may not represent that sort of situation. And in most cases involving diagnostic tests, universities have been quite vigilant about ensuring end-user access. Myriad, unfortunately, represents an exception to that rule that I'll talk about in a minute. And then finally, the last piece of the overview, we have the insurance piece. And here, as I've mentioned, a primary goal is access. In the U.S., as you all know, we have a hybrid system of public and private insurance, and here it's pictured as of 2011. To a significant extent, the specific goal of insurance is, of course, to insulate patients from the cost pressure that they might otherwise feel, and thus promote access. But this insulation from cost pressures is also a double-edged sword. It's both a vice and a virtue. As a consequence of this insulation from cost pressures, we have a situation where health care costs are rapidly, if not already, becoming unsustainable. How does this play out for the biopharmaceutical industry? I think for purposes of the biopharmaceutical industry, in the not too distant future, there is going to be some pressure to exert demand-side bargaining power, particularly on the public side. And I suspect that this demand-side bargaining power pressure will become even more acute after the passage, or because of the passage of the Affordable Care Act. Medicare and most state programs don't have demand-side bargaining pressure right now, but I think that situation may change in the future. All right. This is just an interesting chart, I find interesting anyway, showing that even currently the U.S. already spends more public dollars per capita on health care than does Canada. So there's a huge public role with possibly associated demand-side pressure on costs already. These are just some CMS, Center for Medicare and Medicaid Services, cost projections about what the public sector role will look like circa 2020. Now let's turn to the Myriad case, which I think provides a very nice example of the conflicting roles of patents, public biomedical research funding, and the health insurance system. So in this case, a group of physicians that are involved with the Association for Molecular Pathology are represented by the ACLU and a group called the Public Patent Foundation, and they are challenging the breast cancer gene patents either owned or exclusively licensed by Myriad Genetics. They filed what's known as a declaratory judgment action challenging these patents as invalid. The story of these patents is very interesting. Many of these first patents were the result of public funding and, as a consequence, were owned by the University of Utah. Some of the patents actually involved NIH scientists, National Institutes of Health scientists, themselves working on the hunt for the breast cancer gene. So NIH is actually a co-owner of some of these patents. In general, with respect to diagnostic genetic testing, it's very interesting that the federal role has been so huge. With respect to the most sophisticated studies of these patents suggest that as many as 50% of these patents probably involve some federal funding. I think part of the reason for unease and a reason for the litigation in this case is not patent law per se, but this sense that federal funding was so deeply involved in the research that led to the patents that, as a consequence, diminished access to the results of the research is really truly problematic, more problematic than in other cases where federal funding was not involved. This very important role of federal funding perhaps is even more critical because in the case of diagnostic tests, unlike in the case of drugs, we don't necessarily need a huge amount of additional private funding to bring the invention to market. Drugs are obviously heavily regulated by the FDA. In contrast, currently, most forms of genetic testing are not heavily regulated, so there isn't a need for huge additional private investment. And that makes the concern that publicly funded research is being patented and then exclusively licensed for private gain, or at least the story would run that way, more acute. This concern, not only in the Myriad case, but more generally, was sufficiently acute that the Secretary of Health and Human Services actually commissioned one of its advisory committees to write a whole report focused on the public funding role and the question of patient access to these genetic tests in general, not simply in the case of Myriad, but in general. So this report came out in 2010, and it's a fairly, I think it's fair to say, a fairly scathing indictment of the lack of access provided in particular by Myriad, but also by other genetic testing providers that are exclusive licensees of patents that often were federally funded. In particular, with respect to Myriad, there's a lot of anecdotal suggestion in the report that Myriad didn't do enough to work with state Medicaid providers to ensure that state Medicaid coverage would be available for breast cancer testing. Now, this report has been criticized for relying largely on anecdotal evidence, and I think that's a fair criticism. That said, the report definitely hit a nerve and I think has created a lot of the momentum behind the Myriad case certainly sufficient momentum that one of the judges in the case at the Federal Circuit level, the Court of Appeals at the Federal Circuit, which is the intermediate appellate court, cited the report in his dissent in that case. And I'll talk about that in a minute. However, in keeping with the dominant innovation narrative of patent law, the part of this report that was cited and the way that this litigation has played out in Myriad has, for the most part, continued to focus not on access by patients, but on innovation. So at the Federal Circuit, the intermediate appeals court that hears all patent cases, the majority decision specifically states that this appeal is not about whether individuals suspected of having an increased risk of developing breast cancer are entitled to a second opinion. One of the complaints against Myriad is that it has its exclusive rights over the breast cancer genes prevent other clinical providers from providing second opinions when the Myriad tests are inconclusive as to the relevance of the mutations that have been identified. So Judge Lurie makes a point of saying that it's not about access, which is in keeping, as I said, with the dominant innovation narrative of patent law. Even some other actors, like the dissent that cites the Secretary's Advisory Committee report, tend to focus on innovation, and I think that's because it's only acceptable in the narrative of patent law to talk about innovation. It's not really acceptable to talk about patient access. And this slide points out that Bryson's dissent, which draws a distinction between different types of gene patents that we can talk about in the Q&A. It's a relatively fine distinction between different types of gene patents. Really draws this distinction for purposes of saying that, well, the gDNA patents we want to knock out because they would impede follow-on innovation, but the cDNA patents are okay. Similarly, the Department of Justice, which has filed a brief in this case, both at the Federal Circuit level and at the Supreme Court level, distinguishes between cDNA and gDNA and talks wholly, entirely about the innovation issue. Still, I do wonder whether at least part of the motivation for the deep interest by the Supreme Court in this case and in other biomedical patent cases is at least sub silencio or concern about end-user patient access. The Supreme Court in particular has taken a series of these biomedical patent cases that I'll talk about in a minute that don't necessarily represent the area of patent law where we see the most problems, as I've suggested in showing the kind of spaghetti against the wall diagram of the telecommunications patent litigation. Most insiders within patent law would say the information technology industries are where the biggest problems are, not as much in biopharm. And so I do wonder whether sub silencio there is some concern about end-user patient access of the sort that was enunciated in the Secretary's Advisory Committee report. In any event, I think, just to put my opinion on the table, I think it's somewhat problematic to use patent validity doctrine to address questions of end-user patient access. I think that's a very blunt tool for addressing concerns that are very real and very legitimate, but to use validity doctrine to address them is using, I think, a sledgehammer to swat a fly and not appropriate. In this case, it seems to me the Myriad litigation in particular and a lot of the problems around genetic diagnostic tests and access to results from genetic diagnostic tests could have been avoided through norms and soft law, and for the most part have been avoided through norms and soft law, with the Myriad case in the University of Utah being a notable and very unfortunate exception. So how? Well, NIH actually has done a lot of work in this space. Despite its general overriding concern with innovation, it also has in this space been concerned with end-user patient access issues and issued guidelines way back when, about 10 years ago, talking about appropriate ways of licensing in particular genomics patents, so as to ensure end-user patient access. Most universities have fallen in line as well. So these 9 points to consider in licensing university technology from 2007 are consensus guidelines that most universities have signed on to, saying specifically that exclusive licenses should be granted where necessary to encourage development, but in general, consideration should be given to means for ensuring reasonable access for patients and shielding individual healthcare providers from the risk of suit for patent infringement. The guidelines also talk about how licenses should be structured so as to not hinder clinical research, professional education and training, and the like. These norms in soft law have, for the most part, been followed by almost all universities, again, with the University of Utah being a notable exception. So, unfortunately, because these norms in soft law were not followed completely, we do have this case before the Supreme Court. In this less than optimal situation, what should the court do? Well, I think the best case scenario would be to follow the lead suggested by the United States government in this case. And truth be told, I do have a bit of a conflict of interest since I helped to craft this position when I was in the U.S. government, but I still believe it. The position taken by the USG would affect the so-called gDNA patents that I mentioned, and thereby affect certain companies that build their business models on those gDNA patents, and those are primarily diagnostic testing companies. But I would argue that those diagnostic testing companies don't really need those patents. The evidence suggesting that those patents are really necessary for their business models, I think, is at best mixed. Without those patents, clinical providers would be free to provide their own genetic diagnostic testing. I'm not worried about the threat of lawsuits. By contrast, so-called cDNA patents and other types of genomic-based patents are quite important for biopharmaceutical innovation. And the government position would preserve all of those patents if it was followed rigorously. What I do get concerned about is loose language by the Supreme Court that wouldn't tightly adhere to the narrow distinction crafted by the U.S. government. Unfortunately, the court, because I think it has an interest in this issue that may be triggered in part by concerns about end-user access, tends to sometimes get a little bit sloppy, as it did in a case it decided last year called Prometheus versus Mayo. In that case, Justice Breyer, writing for the court, issued a sweeping statement saying that laws of nature are not patentable. And again, I think it was perhaps prompted by the fact that this was a medical diagnostic patent. The patent at issue actually was a very narrow patent. It covered adjusting the dosage of a particular drug on the basis of certain metabolite levels of the drug found in a patient's blood after the drug was administered. So a fairly, in fact, quite narrow patent. Nonetheless, Justice Breyer, writing for a unanimous court, issued a sweeping statement about the supposed preemptive nature of this patent, that this patent would preempt so much future research. And that statement about the preemptive nature of the patent struck me as ringing a bit hollow, because this was really not a sweeping preemptive patent. And this, in general, the decision could call into question lots of narrow patents that are quite important for the emerging field of personalized medicine. Personalized medicine, as many of you may know, is a field that bases its methodology on the idea of tailoring therapies to particular patients, and therefore will often require very detailed information about the expressions of, for example, gene levels in a patient or other types of so-called biomarkers. And those sorts of measurements might be considered laws of nature under Justice Breyer's opinion. I think that's quite problematic. In the Prometheus case, the court could have rendered a much more narrow decision. I do wonder whether its rendering of a very sweeping decision was motivated in part because of the particular nature of the patents in this case. So, in sum, I think genes and diagnostic testing represent an area where the relevant regimes and institutional frameworks, patent law, federal funding of biomedical research, health insurance, have done a pretty good job of balancing innovation and access, but not a perfect job, as the Myriad case reveals. And as a consequence, we have the Supreme Court weighing in on this question, and I do get concerned about sweeping rulings from the court at the end of the term. In the future, I suspect these tensions between patents, markets, and medicines are going to become even more acute. So already we're seeing problems in the area of drug patents, so-called small molecule drug patents, where there's another case actually before the Supreme Court on issues relating to so-called secondary or evergreening patents on these drug compounds, and whether, in order to protect these patents, pharmaceutical companies should be allowed to pay off, quote unquote, generic companies that might otherwise be inclined to challenge the patents. That case, FTC versus Actavis, was argued just a few weeks ago. The concern there among those who are quite worried about this so-called reverse payments regime that pharmaceutical companies have been adopting in many of these cases is that essentially pharmaceutical companies are improperly extending the life of their core compound patent by adding on essentially invalid patents, and thereby obviously diminishing patient access. This problem, I think, is going to become even more acute in the context of these so-called biologics drugs that I've mentioned. Small molecule drugs, at least eventually, will face the threat of generic competition. Even if these reverse payments continue, ultimately you can't evergreen, file these secondary patents forever. In the context of biologics or specialty drugs that are proteins, currently we have only a very nascent possibility of a follow-on generic type regime. This was passed as part of the Affordable Care Act back in 2010, but how robust that will be, whether in fact there will be robust generic competition in the future for biologics, is really unclear. And so, as a consequence, at least for the foreseeable future, biologics producers, Genentech and the like companies that produce primarily biologics, and actually many pharmaceutical companies are getting deeply in the biologics space because there's so much money to be made, will be able to charge large sums of money because there is an absence of generic competition. There, I think the consequence will be that there will be some pressure brought to bear by insurers. In particular, public payers may try to use the big stick of demand-side bargaining power to bring down cost. And I'll end with just a little bit of a teaser into that possibility. This is a New York Times editorial authored by an advisor to Medicare, CMS, who also happens to be a physician who heads up technology assessment for the Memorial Sloan Kettering Cancer Center, a very prominent cancer center, obviously. last year, he and his colleagues authored an editorial talking about how the typical cancer drug now coming on the market, which is usually a biologic, costs these days about $10,000 per month. Two of the new cancer drugs, they say, cost more than $35,000 per month. In contrast, a decade ago, in part because many of the old cancer drugs are small molecules rather than biologics, they cost about $4,500 a month. In this case, Dr. Bach decided, and this is very interesting, to simply not prescribe, not allow MSK to prescribe to its patients one of these two new cancer drugs because they cost so much. Now, MSK is not even the payer in this case. It's just the provider. He determined, however, that an off-label use of Avastin, which is significantly cheaper, was just as effective, and therefore he wouldn't even allow MSK physicians to prescribe the drug. Now, this may be a taste of things to come. Peter Bach is a very prominent thinker in these circles, and the Kaiser Permanente system is another system that follows his work quite closely. Now, currently, the Medicare system is prohibited from using techniques of cost-effectiveness analysis, which explicitly consider these cost determinations. And so it appears the literature suggests it covers a fair number of innovations that aren't particularly cost-effective from conventional, according to conventional measures of cost-effectiveness. I do wonder whether that is going to change in the future because these types of costs simply aren't sustainable. So I really appreciate this opportunity to discuss tensions between innovation, cost, and access in the complex ecosystem of biopharmaceutical innovation. And I really look forward to your questions. Thanks.
So we have set this up in such a way as to ensure that there is the opportunity not only to hear from Professor Rai, but also to engage with her. And we have a good 15 or 20 minutes in which we can do that. And so my ordinary role here is to call on folks and to relieve you of that deep burden as a law professor of calling on folks. It's the only thing I can offer. So if you would please raise your hand. If you're in the lower bowl, you can press the button in front of you, and the rest of us will be able to hear it. And we will start with you. Please hold that down while you know the... Yes.
Oh,
hold that
okay.
down while you ask your question. Nice.
So with respect to access, so for example, in India, we've seen recently sort of the forced access to these high-cost drugs. Now, some say that's kind of a rogue way of addressing the issue of access. How do you think people in the Western world will do similar things?
So that's a great question. I believe you're probably referring to the case that was recently decided by the Indian Supreme Court with respect to the Gleevec patent, which I should note, just to be clear, that wasn't the primary patent on Gleevec. The primary compound patent on Gleevec couldn't be filed in India because India didn't sign on to Western pharmaceutical laws until 2005. That's a little bit of a shorthand way of stating the proposition, but I think it's mostly accurate. So this is a secondary patent on Gleevec, a patent on a particular formulation. Now, whether what the Indian Supreme Court did was rogue in striking down the patent, which obviously lets the drug continue to be produced by generic companies, is an interesting question. In the U.S., this patent, the very same patent, is currently the subject of a so-called Paragraph 4 challenge under the Hatch-Waxman Act, which is the act that allows generics to come to market, allows them to challenge brand name pharmaceutical patents and come to market if they succeed. We'll see how that challenge works out, because These secondary patents, as I was suggesting, are precisely where I think the battle will be played out with respect to small molecules. Now, again, with respect to small molecules, though, at the end of the day, they're still not that expensive, and ultimately we will see generics. You can't evergreen forever with these secondary patents. And so I do think that the big issue will be biologics and whether and how patents on biologics will be treated. With biologics, we also have a regime of so-called data exclusivity, which gives you 12 years of exclusive protection. And that's another level of protection that may be harder to overcome for generics than the patent protection, frankly. And I think that was very much in the minds of the folks who lobbied for that protection in 2010.
We had a question back here, please.
Thank you for your presentation. I'm not a law school student. I'm a student in biomedical engineering and have some patents and really interested.
You're a future law school student.
Everyone should be a future law school student.
Yeah, so as my understanding, pharmaceutical companies have a lot of patents that expiring soon or already expired.
Yes, indeed.
So they are going back to their pipelines instead of developing new drugs. So what patent law gonna, influence that process, and also how pharmaceutical companies gonna, react to whatever the law process is going. You answered a part of my question, so I'm ending my questions.
So it's a great question. It is true that the pipeline for small molecule chemicals is pretty dried up, and those patents are ending, and it's unlikely that the pharmaceutical companies will be able to evergreen them forever, which is what the secondary patents attempt to do. That's why I think the role of biologics is even more critical, because there the pipeline isn't necessarily particularly dry. There we have some more production in the pipeline, and those drugs are really expensive, and that's where I think the cost pressures are really going to be brought to bear. I mean, my view of the small molecule chemical cost pressures and the patent protection that leads to those small molecule cost pressures is yes, but that ends. With biologics, we may not have an ending as a consequence of a possible reluctance to have a really robust biosimilar, i.e. generic follow-on biologics regime, and the 12 years of data exclusivity. So my concern about the future really is more on the biologics end than the small molecule end. And I think the flip side is that pharmaceutical companies are much more interested in the biologics end these days than I think they are in the small molecule end of things, which is one reason, by the way, just to circle back to the Myriad case for a moment, it's really important, I think, from my standpoint, for the court to be very narrow in its decision making, because if it renders a sweeping decision, that could really throw into question patents on biologics. And much as I'm concerned about biologics costs, I think patents on biologics are important.
Other questions? Yes, please.
Yes. Do you see a risk that because of, in retrospect, what seemed to be bad policy decisions by the federal government in terms of the way they allowed their funds to be used and the licensing obligations that they didn't impose, do you see a danger in courts attempting to correct that now apparent bad judgment by making bad patent law in terms of validity?
That's precisely my concern, that the Supreme Court is stepping in to address a problem that is a problem of bad licensing, where NIH tried to use its soft power to encourage University of Utah to follow along and also ultimately also encourage Myriad, but ultimately wasn't successful and perhaps wasn't as forceful as it should have been. Absolutely. And as a consequence, we literally have a Supreme Court case over this issue, again, using a very blunt doctrine to address what is really a licensing problem. And I have argued in the past that the agencies that fund federal, that fund research should be much more aggressive about monitoring licensing by the recipients of their federal funding.
Bruce, please.
Well, to follow on to that question, in your ideal world of patent law, what if patent validity or patentability doctrine is too blunt an instrument? What legal tool should the court use? What patent doctrine should the court use to resolve disputes and inject the public interest into patent law?
So I'm going to say something a little bit controversial here, I suspect. I'm not sure that patent validity doctrine should ever be used to address end-user patient access issues. I think the public interest is a broader conception. The public interest includes interest in innovation, but I think that patent validity doctrine really is a tool that's best designed for promoting innovation concerns. I think licensing doctrine, antitrust doctrine to some extent, those are the tools that the court should use, but not validity doctrine.
Is the distinction that the government proposes groundable in the text of the patent statute? I'm sure the answer to that has to be yes, but
of course.
I'm curious as to how that can be if the distinction is between the cDNA and the gDNA.
So the text of the patent statute is very sparse. The patent statute is similar to the antitrust statute in this context, at least, in basically saying nothing about what is really patent eligible. So the doctrines of product of nature and laws of nature as exceptions to patent eligible subject matter are purely common law. And so the court is essentially interpreting its own common law exceptions when it's taking this case.
I see. Other questions? Yes, go ahead.
For those of us that at universities who are trying to work to craft these patent applications, there's a missing piece, perhaps. So we've heard the pharmaceutical companies are doing this, the NIH is doing this, the universities are doing this. But look at, really, the claims are crafted by the attorneys. Okay, it's not like the president of Pfizer is saying, get us the broadest claims. You are being hired by Pfizer in a way to do that. So where is the profession, the law profession, in this discussion about what is fair? Or maybe that's irrelevant because you just go with what the law and case law dictates, that's what you do. You know what I'm saying?
So yeah, I think that as a matter of practice, the patent prosecutors will go to the limit of what the law allows them to do, not traverse over the limit, but go to the limit. And that's actually encouraged, I think, to some extent by legal training. Now, and again, I think the public interest in terms of non-innovation related public interest, so to distinguish, Professor Boyden asked about the public interest, and I guess I would distinguish between innovation related public interest and access related public interest. I think the access related public interest is not really, that's not really, and here I do adhere to the conventional wisdom to some extent, is not really something that patent validity doctrine can address. And so patent prosecutors that really are thinking only about patent validity when they prosecute the case can't really, or they're not institutionally well suited for addressing that interest. I think that's where funding agencies come in, where antitrust law comes in, where principles of licensing come in. And at the end of the day, where a robust health insurance system, albeit one that's attentive to cost concerns, also comes in.
We have time for several more questions. Yes, please.
Thank you. Well, as I understand it, you said you don't believe that patent validity should have anything to do with the public interest and access. Do you believe that the increased tensions that will come from this interaction between the need for access and the need for innovation would cause perhaps a new doctrine in relation to public interest and access to be incorporated into either patent prosecution or the review of patents after they've been prosecuted?
Whether it will happen as a descriptive matter, like whether I would predict that it might happen, I think it's certainly possible. That's clearly what's going on, at least in part in India. India's decision to overturn that particular secondary patent was motivated, I think, in significant part by access concerns, end user access concerns, as opposed to innovator access concerns. So as a descriptive matter, I think that might happen. I would, as a normative matter, prefer it not to happen, because I think, again, that these are, patent validity is a very blunt tool, and I think, unfortunately, well, for better or for worse, we have a patent validity doctrine that applies across all industries, not just the biopharmaceutical industry, so anything that would emerge in the biopharmaceutical industry would also have implications for other industries where probably there might be unintended consequences as a result. So, but as a descriptive matter, in terms of prediction, I think it's entirely possible. And I think that, as I've suggested, I think there may be sub silentio, at least some of this, in the Supreme Court's extreme interest in taking these biomedical patent cases. Again, most patent lawyers would say that the big problem is information technology right now, in terms of just people suing the living daylights out of each other. But the Supreme Court seems to be much more interested in these cases.
Yes, please.
Here, I see. So I'm a researcher up the street at the Medical College of Wisconsin, and I'm going to take the fifth on being a future law student, as my wife is saying. But my question is, with the Myriad case kind of arose before the age of the emerging technology of whole genome sequencing. So I'm curious what you think the interaction between the issues in the case of the Myriad case are going to interact with the new technology of
whole genome sequencing. So great. So one of the reasons I am very supportive of the government's position distinguishing between gDNA and cDNA is not only because it's consistent with the statute, since the statute says nothing, but also because I think gDNA patents, in addition to not really being necessary for innovation in the diagnostic testing space, also have some possibility of hindering progress in the development of whole genome sequencing technology. And that's what Judge Bryson focused on in his dissent, where he agreed with the government's position. And I think, the evidence is not, in fact, I just, before I came into deliver this lecture, just got an email about another conflicting article that just came out with respect to the extent to which gDNA patents might create patent thickets for whole genome sequencing. So the evidence is not undisputed, but I think on balance, given that there's a potential for problem, and there's no real benefit from these patents, I think at the end of the day, we should just go ahead and knock out the gDNA patents.
If you're pleading the fifth, we'll give you the equivalent of AP credit with respect to criminal law. You're right into the upper level courses. No exemption from civil procedure, though. Yes, please.
Right there. Okay. Hi. I'm Marge Siebert. I'm from the nursing college, so I'm not a lawyer either. And I'm interested in consumer health technology, and I'm developing decision support tools for patients and caregivers. And my understanding is I should only consider copywriting that. It would be an application for an iPad. Is that?
No, for better or for worse, you need to consider patents as well. You're talking about decision support tools, health information technology. Yeah, no, software patents are very prominent in that field. So for better or for worse, I don't know whether you're considering them from the defensive side or the seeking a patent side, but yeah, patents are definitely a piece of the puzzle there.
Please, we have time for one or two more questions, so go ahead.
Excellent, thanks. So let me take this, present the question from a different perspective on policy. So I'm not a patent person, but I represent a lot of life science companies from the FDA perspective, clinical research and pre-market, post-market.
Sure.
Whole thing. And the patents and the reimbursement, it's about getting some of that money back from all of those huge costs you
Right.
to get a product to market.
Sure.
So if we restrict patents and comparative effectiveness is restricting reimbursement, how can they make enough money to do the innovation on that side? So do you have any suggestions from a policy perspective how we can make it more affordable for these innovators to get their products to market in a regime that might have less patent protection, lower reimbursement, clinical research costs? Any thoughts there?
So yeah, so I've thought to some extent about how to essentially streamline the R&D process so as to make it cheaper, so that at the end of the day, even if we do have comparative effectiveness analysis, that's not going to choke innovation, because innovation is cheaper, and therefore you can come in under the cost ceiling put in by insurers. Yeah, so there's a lot of hope, I think, and I think to some extent justified, that I mentioned personalized medicine already, that we can have more streamlined clinical trials, because if we determine that only particular patients have the relevant biomarkers to participate in a particular trial of a drug, you can get efficacy, particularly in so-called phase 3 context, much more quickly and cheaply. Now, of course, that makes your patient population to whom you can sell perhaps smaller as well, so there's a flip side, as you probably know. But that, that is the hope, that with greater information, essentially, about what you're targeting the drug for in terms of the patient population, one can streamline. I think the FDA has a lot of work to do as well. I would agree with those who say that it's probably too risk averse in terms of its what it requires. That said, I'm not sure I would blame the FDA so much as I'd blame oversight by Congress, which tends to be, create problems for them, and they're responding to their congressional overseers more than anything else. So those are just some thoughts. There's also, and I'm particularly interested in this possibility, given that I really hope that the small molecule possibility doesn't just go by the wayside. I hope that there's some sort of new platform that allows small molecules to once again become a flourishing area of inquiry, because they are less expensive to develop at the end of the day. That we might be able to, and I'm involved with the NIH and working on this project, we might be able to repurpose molecules that have failed, not for safety reasons, but for efficacy reasons, for different uses. And that would be, relatively speaking, a cheaper way of going about things. So that's one effort that NIH, with which I'm very much involved at NIH.
I think that is a good place to leave it, both substantively and in terms of time. I want to thank Professor Rai for an especially engaging Nies lecture. Thank you.